keep the records of the entire recruitment process for a 5-year period from the date that the application is filed. So it's important to understand amongst the company and their counsel who's going to keep those records, and that if there's something in writing about who's responsible for doing that. Finally, because of the market conditions, this layoff requirement is even more relevant than ever before. The PERM regulations say to a company, if you've had a layoff in the area of employment and in a the same or related occupation within 6 months prior to filing the PERM application, then you need to reveal that on your application. Most companies, if they've had a layoff, will not actually file the application because they don't want the undue scrutiny that they may get from the Department of Labor in that situation. But the rule is that if there has been a layoff in that same location and U.S. workers were laid off, you have to be able to show that they were not working in the same or similar occupation, or else that you considered them for the job. And if they could have done the job, then it's not appropriate to move forward with the PERM application. So the Department of Labor takes that very, very seriously. And so what most companies end up doing is just waiting and not filing for permanent residence for an employee if there's been a layoff. But what the lawyers do is spend a lot of time looking at the nature of the jobs that were subject to the layoff, whether the occupations were close enough to the one being sponsored, or whether it's in the same geographic area or not. If you have a layoff in one state, but the job's located in a different state, it's okay. What really matters is the specific geographic location where the job is located. So does anyone have any questions about the PERM process? Okay. Finally, just a few words about corporate immigration policies and best practices. Should a company have an immigration policy or not? What should the policy address? What are some of the sponsorship considerations? So that relates to green card sponsorship, otherwise known as permanent residence sponsorship, and current trends. As a general rule, a very small company, company under 50 or 100 employees often doesn't need to have an immigration policy. It's the companies that are larger that frequently can benefit from having an immigration policy. An immigration policy can be a very good thing because it promotes consistency and transparency across an organization around the benefits that the company is willing to provide to employees who are on visas and may or may not be sponsored for green cards. A policy would lay out the kinds of jobs that are subject to sponsorship for green cards, or the levels of positions that are. It would lay out the time frame for sponsorships. Frequently, a company will say, we reserve the right to sponsor you for permanent residence under certain conditions, but you have to complete at least X amount of employment with us before you are eligible for consideration. And that varies from company to company. It's usually at least a year, sometimes more. It depends on the company. And the considerations usually are tied to performance. It's usually a requirement that the person have had good performance reviews in order to qualify for sponsorship for permanent residence status. The policy can address many other things, but the most important thing is eligibility and timing. And, of course, payment. It used to be the case that a company could tell an employee, yeah, we'll sponsor you for a green card, but you have to find a lawyer and you have to pay for the process. The payment part has changed. The Department of Labor came out with new regulations 2 years ago that dramatically changed that. It used to be the case that it didn't matter who paid for the green card process. And now the Department of Labor regulations require by law that the employer pay for the PERM aspect of the green card process. Now, the perm part is what I was just describing. That's the first step of 3 different steps to get an employee a green card. And the perm part is the most time-consuming part of the process and, frankly, the most expensive part, because there are a lot of steps that have to be gone through to demonstrate a good faith testing of the labor market. And sometimes the Department of Labor will audit the application, and there are additional costs associated with responding to an audit. They audit a lot of these right now just for quality control purposes. And the employer must pay all the legal fees and the advertising costs of advertising the position in the newspaper, which is a requirement. Absolutely have to advertise in a physical newspaper, even though that's very old-fashioned. And it's costly to do that. Sometimes the ads can be $2,000, $2,500 for one of these permits. That cost may no longer be borne by the employee. You can't ask the employee to reimburse you, even if they leave a company. So that has changed the equation on these immigration sponsorship policies, and a lot of the policies that companies had were rewritten 2 years ago when the law changed. So it's in a company's best interest to have their own counsel who is representing the company and is going to do what's in the best interest of the company. And of course, you have to pay now. You have to pay the lawyer for the perm part of the green card process. Most companies, if they pay for the green card, will pay for the whole thing. But what's happening lately, the trend is, with the economy in the shape it's in right now, and money being very, very tight at almost every company, some companies are changing their policies to reduce what they pay for in terms of family members. So, for example, a company may have previously paid for the employee and his or her spouse and children to get their green cards, because there's an additional cost associated with each person's separate application for permanent resident status. It's not just one that's filed for the employee and the whole family rides along with it. The family can benefit, but each one needs a separate application, and it's a complicated set of documents. It's kind of like a real estate closing with lots of different forms and papers. So there's a cost associated with each individual family member's case, and increasingly companies are telling their employees, you may have to pay for either you're going to pay for your own family or we're going to ask you to reimburse. And reimbursement is something that hadn't been paid attention to by some companies until recently, but many companies now are drafting a reimbursement policy so that if a company does sponsor someone for a green card and that employee leaves the company within a certain period of time, they are agreeing to reimburse the company for that portion of the legal fees and outside costs that they are legally allowed to pay for. We actually spend a lot of time helping our clients with those reimbursement agreements that the companies must sign at the same time the company agrees to sponsor them for permanent resident status. So the trend is to become more prudent around the costs associated with the green card process. So that changes with the economy. You know, it goes up and down depending upon how the economy is doing and how companies are doing. And that is a fluid thing, and the policies can change from time to time. Does anybody have any questions about an immigration policy and what it might contain? Okay.
Susan, just going back to perm for just one moment before we let you go today, and we thank you so much for this wonderful presentation. Do you have one question from the audience about whether or not you can include a foreign language requirement in perm compliance?
Okay. You can, with a caveat. There is a doctrine called business necessity, and the Department of Labor needs proof that any kind of requirement in a job that's considered out of the ordinary must be proved to be required on the basis of business necessity. So if you have a foreign language requirement, it's very, very important to document that the job could not be adequately performed if the person could not speak that language. And it can be done, but it requires documentation.
And at this time, we'd like to see if we have any other questions from our attendees. Please take a moment and type those in. And you'll want to use the Q&A panel. And that's on the lower right-hand side of your screen. Susan, it looks like we don't have any other questions at this time. We have had some wonderful questions throughout the presentation.
Yes, well, it's been a pleasure talking to everybody, and if anyone wants to follow up with me, I'd be happy to talk to you by email or by phone.
And Susan, if you don't mind, if you could put your contact information up on our screen today.
Oh, there we go.
Let's see if it's, there we go. Wonderful. Well,
okay.
And as a reminder, Susan's law firm has offices throughout the U.S. and the U.K., and her contact information does appear on your screen at this time, so please do take a note of it and get in touch with her with further questions. And please remember to visit the forum section of the Patterson's online community for further discussions as well as information about upcoming events. Thank you again, Susan, and thank you to our attendees today. We appreciate your time. This was a wonderful presentation, and we hope you'll join us for future events.
Thanks so much.